The deadline has come and gone for the Hochul administration to appeal a trial court ruling that annulled the state's wetland regulations written to implement a 2022 state law designed to expand protections for freshwater wetlands in New York, including a more expansive definition of what actually constituted a wetland. For more on what it means for the underlying statute and why the state may have chosen not to appeal its initial loss in court, we're joined in the Capitol Press Room studio by Tom Berkman, a partner with the law firm Hodgson Russ, who previously served as general counsel for the State Department of Environmental Conservation. So the state Supreme Court decision back in April impacted what's known in the trades as Part 664 freshwater wetland regulations, and we did a deep dive into what this meant back in April with the Sierra Club and Riverkeeper, which listeners can find in the show archives. But can you give a brief refresher on the impacted rules as well as the underlying statute?
Sure. I think sort of starting at the beginning as to what the law fundamentally changed, it really was a sea change in how the state was addressing wetlands. Previously, there was a definition of wetlands, but for the state to have jurisdiction over them, they had to be mapped. Here, the law changed that. It said, no, in fact, it's just definitional. In addition, which I think was really the heart of the litigation and which I think ultimately the stakeholders had concerns about, particularly the developers, were the unusual importance wetlands, right? So these were wetlands of any size that met certain characteristics. Urban areas was particularly one that folks were focused on, as well as vernal pools. And there's 10 other sort of characterizations there. So ultimately, by not having maps in place, the department had to come up with a process. How do people know if, in fact, there are regulated wetlands on the property they're looking to develop or whatever actions they want to take? So that they set up regulations that set forth sort of a process that led to sort of jurisdictional delineations and determinations. So you could go in and ask for, does this tax parcel or does this piece of land have a wetland on it? And they could do it remotely. And they set up that process through the regulations. They further defined those categories that I talked about for the unusual importance. They gave them a little more detail. And I think that's really an important part of that decision and an important part about the law and really impacts ultimately what are the options and why the state may be taking the actions it's taking today. The law itself, I indicated, did have a definition for wetlands, and those were for those larger wetlands of 12.4 acres or more, and then ultimately it'll become 7.4 acres or more in 2028. But for these smaller wetlands of unusual importance, sort of key component of that definition was, yes, it is a wetland. It meets one of these categories, those 10 or 11 categories that are described in the law, and as determined by regulation, right? So ultimately, you have this decision now that says we're throwing out these regulations based upon what the court perceived as not complying with SEQR.
The State Environmental Quality Review.
Yeah, sorry, I'll try not to use acronyms. So once those are thrown out, the question is, can the state regulate those wetlands of unusual importance where the law itself defines them as not only meeting a certain characteristics, but also as defined by regulations? If there are no regulations, are they regulated?
Yeah, DEC has said that it's going to continue administering the Freshwater Wetlands Act with respect to wetlands that remain under that statutory jurisdiction. But as you pointed out, with a lot of laws, if there's ambiguity or specifics that need to be hammered out, it's the regulations that are where the rubber meets the road. So what is the substantive impact of what the state environmental regulators are looking to do moving forward under this new paradigm where their existing regulations have been shot down?
Sure. Well, the first place to start is wetlands are still regulated, right? This decision didn't say, it's a free-for-all out there. There's no longer wetlands in the state of New York. That's not what it did. Ultimately, what the state is doing in this particular circumstance is it's saying, we are going to regulate previously mapped wetlands, and that was the previous sort of rubric that we were operating under. In addition, the state is going to continue to regulate those wetlands that are 12.4 acres or more, even if they're not mapped, because again, it was defined in the new law. There was not a need for maps, and that is sort of the full sort of circle for those wetlands. Does it meet the definition? The state, however, has indicated that that's all that they're regulating, and previously mapped wetlands, because you could have had some of unusual importance that were previously mapped. They have been silent as to whether they would regulate the unusual importance, and I take that as not regulating those at this juncture.
That's a good way to interpret state government.
So those remain now this open question. So the issue I think that developers and others are facing, there's been thousands of jurisdictional determinations that were made during that time period, right? Because everyone who wanted to do a project and wanted to have sort of an understanding whether they had to get a permit or not went in and got a jurisdictional determination. Many of those came back positive based upon these smaller, unusual importance. So developers are sitting with a positive declaration or determination that says, hey, you need to get a permit. Obviously, those all are eligible for reassessment at this juncture. And the department has made it clear that you can go through a process to have those reassessed based upon this new sort of standard that is out there.
In striking down the DEC's rules, the judge found issue with the process that they took in writing those rules. So is there anything that stops the state environmental regulators from simply going back to the drawing board and crafting regulations in a way that would withstand a potential judicial challenge?
Well, I think two things are at play here. You're right that ultimately the state elected not to appeal this decision. And I think this was covered somewhat, or someone predicted that this might be one of the reasons, is because there's parts of this decision that are really favorable to the state, right? Ultimately, the law survived. It was not thrown out for due process or constitutionality, vagueness, or things of that nature. So that's a really good sort of piece that, structurally, these regulations were found to be constitutional and proper. What the court did find was that you didn't go through the proper sort of environmental review. So ultimately, I think the department has a number of choices. They can simply do that environmental review, a more robust environmental review, and seek to adopt the same regulations that they put out. Or they may address, certainly where the court pointed out, really two areas that they felt the department had used discretion beyond just enacting the legislation. And part of that was the urban wetlands that we were talking about that really have been the focus of the developers, as well as the sort of the default 100-foot adjacent area. So the court said, hey, these are two aspects of this rulemaking that were discretionary. It yet to be seen whether the department will revisit that. In this case, I think the court had identified that for the urban wetlands, there was a default to. Wetlands are classified from 1 through 4. The default was to class 2, which is a pretty stringent classification. He mentioned that was a discretionary determination. I don't know if the department will revisit that aspect of it.
Historically, given your experience at the higher echelon of power in the DEC, how does a decision like that get made about what is going to happen? Is that something that you got to go knock on the second floor and this comes from the governor's office? Or historically, is that something where the leadership of DEC has a lot of flexibility?
Well, in this case, I think the law really is what controls this, right? At the end of the day, the department is implementing a law that calls for regulations, and it has various sort of boundaries within it. So I think there is relatively limited, there's a limited amount of things that you can do based upon where the law currently stands.
But what about taking another stab at regulations? I mean, how does someone decide whether they're going to do that or not? Who usually is pulling the strings there? Is that usually falls on the governor, depending on who the governor is and how much authority they're willing to delegate? Is this something where the DEC commissioner has broad latitude? What's it been like historically?
Well, I will say, it's an executive agency. Ultimately, it's guided both by the laws and policies of the state, and that's really sort of the driving factor. I probably don't want to get into too much detail on how the soup is made, so to speak. But, again, in this case, I think you really have a law that's driving what those regulations can and can't do. And you have a court case that, ultimately has thrown out these regulations, and an agency that hasn't appealed it at this juncture. I will note one of the litigants has put in a notice of appeal. So it's yet to be seen whether that appeal is perfected or not, but that may raise some of the various questions over again. It certainly allows the state an opportunity and a cross appeal if they want to contest the decision.
And that appeal is in technical terms, to me, seems like trying to spike the ball after a touchdown, so to speak, because while they had the regulations struck down, as you pointed out, there are still those constitutional and procedural claims that were rejected by the lower court. And they're looking to have those revisited?
Possible. They just put in, it may just be protecting their ability to have an appeal. It may be that they want to try to influence any future sort of rulemaking. It's unclear, but they're protecting their right to appeal at this juncture, whether they ultimately perfect that or not. But you're right. I think if they were to perfect it, they would be taking, arguing against the decision to the extent that it went against them, those constitutionality questions as to whether the law, in fact, is constitutional in the first place.
Do you anticipate that there will be other efforts to challenge this law in the future, given the new landscape that we have in which these regulations have been struck down? Because like in that previous interview I mentioned at the top, they highlighted how this law withstood multiple challenges before there was this issue with the process. I mean, do you see this as something that is going to be brought back to court in some fashion other than the appeal we just talked about?
I think it depends on what those new regulations look like that the department ultimately adopts. Are they regulations that, again, those challenges are going to be renewed, or are there changes to those regulations in which the regulated community is in agreement with it or not? I think we have to wait and see, ultimately what the department's actions are with repromulgating these regulations. I'd also obviously keep an eye on whether, the legislature wants to revisit the law itself and whether they want to make amendments to the law.
What do you think of the idea that if lawmakers were trying to avoid potential challenges to the implementation of the overall goals of something like the wetland regulations, that they craft a law that removes some of the ambiguity that needs to be addressed by regulations? Because if you have it written in law, it seems like it would limit the potential for judicial intervention, at least to some degree.
Well, certainly, if it removes all discretion from the department, then you don't have those seeker concerns as much. But again, I think the court really was instructing and was indicating to the department that they needed to do, not necessarily change the actual rules themselves, but provide an environmental analysis as to what those impacts are, or a better one in this case.
Yeah. Well, I guess coming back to the state's decision not to appeal, do you read anything broader into that than just a case-by-case decision? I mean, is this something that speaks to larger values or priorities of the administration, or do you view this in just here's one case, here are the facts on the ground, and that's how they looked at it?
I think it's probably more the latter, because there was some real benefits to that decision in upholding the law itself and upholding sort of the heart of what those regulations are. It really was a procedural question that was raised in those. It certainly does give the department another opportunity to revisit and look at it, and we'll see if any changes are made in light of that. But in this case, I think that this is, it's really dealing with, what's the best way and most efficient way to handle a decision like this, right? Is it to try to continue to litigate it, or is there a simpler path in simply going through a repromulgation?
Well, unfortunately, that's all the time we have for this conversation. We've been speaking with Tom Berkman. He's a partner with the law firm of Hodgson Russ. Tom, thanks for visiting us in the studio.
Well, I appreciate you having me.
Support for the Capitol Press Room comes from O'Donnell & Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.